Tension fills the courtroom as the defense pleads for a second chance. A father of 4, desperate to return home, stands before the judge, his fate hanging by a thread. But as the details unfold, the judge's patience begins to fade.
All right. You're requesting an adjournment.
Yes, and a moment to address bond, Your Honor.
All right. Probable cause conference will be adjourned to November 13th, 2025, 9 a.m. As to bond.
As to bond, Your Honor, we were going to be asking for an a reduction in the bond. If not a personal recognizance bond, perhaps a 10% privilege. Mr. Wilson, to my knowledge, has not had any.
The defense opens by asking for a bond reduction. They paint a picture of a hard-working man, devoted to his children, and claiming he's done everything right since being in custody. A GPS tether, new housing options, and a steady job, all offered as proof that he deserves a shot at freedom.
Bond violations while he has been in custody. He has a really good full-time job that he's afraid to lose. He does have 4 children to provide for. One of his children typically stays with him, is now staying with his sister. One of his other children he usually stays with throughout the day, so he'd like to be able to get released so he can go back and take care of his children and be able to provide for them. He also has let me know that he has somewhere else to go. He has he can either go to his sister's house or to one of his children's mother's addresses. Neither of those are in Washtenaw. He's okay getting released on a GPS tether. He has no reason to come back to Washtenaw except for this case.
But the prosecution isn't convinced. They remind the court that this defendant is still on probation for serious assault charges, and a bench warrant has already been issued. The judge's eyes narrow. This is no small oversight. Probation, new offenses, and non-compliance don't mix well in court.
The house that he could go to, his job is in Southfield, and then I believe your sister's address is
Oak Park,
and then the child's mother is in Westland. So really,
the defense tries to recover. They highlight his progress, anger management classes, consistent meetings with his probation officer, even voluntary extra sessions to improve himself. A man trying to change, or just trying to escape the consequences.
Far away from here, well, not really far away, but far enough, we can do a hot zone tether with a GPS zone that's quite big. He will not violate. He just wants to be able to get back to his job so he doesn't lose it, and be able to provide for his children.
Respond.
Your Honor, I'm going to strongly object to any modification of bond. In this case, we originally requested $150,000. He is currently on probation out of the Sixth Circuit Court for a GBH and DV conviction that he pled no contest to. As far as I saw on their website, for that case, a bench warrant had been issued at this time. In this case,
Hold on. I just want to make sure I understand it. At the time, the alleged time of this offense, he's on probation.
for a DV, GBH, and DV charge that he pled to.
All right. And there's a bench warrant that's being issued. Was that bench warrant issued in response, if you know, to these charges, or was there something else where he was non-compliant?
I believe it's these. I don't know exactly. It just says order for bench warrant issued expedited on 10/22 of this year.
If I may, Your Honor.
On 10/22. So that was.
Then the victim's story hits the courtroom like a shockwave. A terrifying account of strangulation, physical assault, and threats. The details are graphic: a mother, her child, and a violent confrontation that ended with police breaking down a locked door.
Probably. Go ahead, Counsel.
Yes, I believe that's his violation. In Wayne, he is in contact with his probation officer. It's a good relationship with her. He knows about that. He's complying with that. He was about to be discharged November. He has done everything he's supposed to do. He was ordered to do, anger management classes, and he completed what he was supposed to complete, and is still doing more classes on his own, whim. He felt like it was helping him, and again, he was doing very well. He was about to be discharged. He was waiting on the discharge letters.
He was doing everything he was supposed to do except have contact with the police.
The prosecutor's tone sharpens. They describe a man with a pattern: violence, resistance, and manipulation. He said he wouldn't kill her, the prosecutor notes, because no one's worth going to jail for life. Those chilling words echo through the courtroom.
To potentially commit other offenses.
Yes,
Right?
Your Honor.
That's what you meant to say.
That's what I meant.
Go ahead.
He was about to another strangulation domestic violence case, and in this case, the victim is extremely terrified of him. She reported 2 different strangulation incidents, one that was out of county and one in Washtenaw, and that the defendant had left her car for an extended period of time and she wanted it back to run errands. He became extremely upset, told her, "Stop telling me what to do or I'll beat your ass." He then balled up his fist, began pushing at her as if he was going to hit her, then pushed her to the ground, which caused her to fall on top of her. He then had one hand around her throat, one over her mouth. While she's still on top of the child, strangled her, and when law enforcement arrives, he refuses to come out of the house. Officers had to kick in the door, which it was stopped partially by the deadbolt. They eventually were able to kick it open fully and arrest him, at which point he was still tensing.
The defense pushes back again, calling the story just allegations. They argue the video footage doesn't prove he resisted arrest. But the judge doesn't seem moved. The tension between both sides grows thick, every word carrying weight.
Playing away. And during these assaults, he had also told the victim, "I wouldn't kill you because nobody's worth me going to jail for life. I'd have someone else do it." So I have extreme concerns given that a new strangulation case occurs while he's about to probation for a strangulation case that he pled to. And he's also resisting law enforcement officers at the scene of this event. So I have concerns for the victim, the community, law enforcement, and the high lethality factors in this case. So I would reject any modification of bond at this time.
I just add, Your Honor, that these are just allegations at this point.
Yeah, but I'm presuming that some of that we can probably see because the door, there's physical damage to the door.
Yeah.
And while there are allegations, certainly there becomes a problem if all of this is going on and there's a lack of cooperation with police officers.
I don't, again, want to speak to the exact details of the case, but from my review of the video, Your Honor, again, I don't want to get into the details, but it's definitely questionable whether he was resisting arrest or not. In my review of the videos.
Finally, the judge delivers the decision. The bond reduction? Denied. With a calm but firm tone, the judge declares the defendant a danger to the community and a risk to public safety. The $75,000 bond stands, and the courtroom falls silent.
In looking at this, frankly, his bond currently is set at $75,000 cash surety. I'm going to deny the request for a reduction. I do find the defendant, having been on probation and then allegedly committing these offenses, to be a danger and risk to the public. Quite frankly, and I did not take their indication of what they had requested as a request to raise the bond in this case. I will decline to do so, although I think that the bond in this court's mind, based upon what I'm seeing, may be set too low. So I'm going to leave the bond where it is. I'll have his bond continue, but I'm certainly not reducing it.
Thank you, Your Honor. Understood.
Thank you.
As the gavel falls, one thing is clear: second chances aren't handed out easily in this courtroom. A plea for mercy turned into a lesson in accountability. For now, Mr. Wilson remains behind bars, awaiting whatever justice brings next.